Namaskar and welcome to the inaugural episode of Insolvency Veterans, a unique talk show where you can hear the experts and practitioners who have been instrumental in shaping and implementing the Insolvency and Bankruptcy Code and who have a deep understanding of its implications and challenges. I am your host, Rajesh Sharma, a former member of National Company Law Tribunal, NCLT. In this talk show, we will explore various aspects of the IBC, such as its objectives, principles, processes, outcomes, and impact on the Indian economy and society. We will also discuss the current issues and challenges faced by the stakeholders involved in the insolvency resolution process, such as creditors, debtors, resolution professionals, adjudicating authorities, regulators, and courts. In each episode, we will have an eminent guest who is a former judge of Supreme Court or High Court or a sitting or former member of NCLT or the National Company Law Appellate Tribunal NCLAT, senior functionary of the regulator Insolvency and Bankruptcy Board of India IBBI, or a renowned expert in the field of insolvency law and practice. Today, we have an eminent and a very special guest in this inaugural episode who demoted his office as acting Chief Justice of Gujarat High Court in the year 2021. But before I formally introduce our special guest of the day, we begin our discussion. I would like to spend a few minutes to explain the meaning of the name of this talk show, Insolvency Veterans. The name is a thoughtful play on words that captures the essence of IBC. The word in has been written in red, that signifies the state of financial stress or insolvency that many companies face due to various reasons. The word solvency has been written in black. It signifies the aim of the IBC to restore the financial health and viability of such companies through a time bound and transparent resolution process. The word veterans refers to the experts and practitioners who have been involved in evolution and implementation of the IBC and who have a wealth of knowledge and experience to share with us. Thus, the name Insolvency Veterans reflects the theme and purpose of this talk show, which is to educate and enlighten the viewers about the IBC and its impact on the Indian economy and society. Please join me in welcoming Dr. Vineet Kothari, former acting Chief Justice of Gujarat High Court. Dr. Vineet Kothari is a former judge of High Courts of Rajasthan, Karnataka, and Madras and demoted his office as acting Chief Justice of Gujarat High Court. Dr. Kothari is now practicing as senior advocate in Supreme Court of India and a senior advisor of KPMG. He is also a chartered accountant, a company secretary, and a PhD holder in taxation policy and freedom of trade. He has decided approximately 50,000 cases in a span of about 16 years as High Court judge. We are honored to have him on our show today, that is the inaugural show of Insolvency Veterans. Welcome, Dr.
Thank you.
Kothari.
Thank you, Rajesh ji. Uh, I must congratulate you, first of all, for organizing such a beautiful talk show. And I feel privileged and honored that you gave me the chance to become the inaugural episode speaker. I'm very grateful to you for all this. I know you very well. You are a very competent chartered accountant and you served NCLT very with a great distinction for large number of years. And after retirement, you are so proactively undertaking these educative programs for the larger benefit of all members of NCLT and NCLAT and general professionals in this field, which is a wide field of this profession, legal services. And I must thank you for all this effort which you have put in. And I feel myself lucky and honored that I am here today with Rajesh to speak my thoughts on this subject. Um, so very grateful to you, sir. Let us begin our discussion.
Thank you, Doctor.
And before you say something more, he tried to explain his insolvency in red and solvency in normal color black. So I would take it as this body of professionals like him to take companies in red in from that red to normal field solvency. And this is how I see this IBC code of laws. And it's a wonderful law, very beautifully enacted by the parliament, and it's consolidation of various laws. And we'll talk about this a little more. Thank you.
Thank you, Dr. Kothari, for your kind words. Dr. Kothari, in your opening remarks, please share that how do you think this talk show will be beneficial for sitting NCLAT and NCLT judges, advocates, insolvency, and other professionals?
Well, Rajesh, I think this is a very good talk show and professional activity which you have done and you are undertaking for a very larger benefit of not only members of Honorable NCLT and NCLAT, but a body of professionals, because these bodies in this special law will deal with very complex and big corporate matters. And as you know, corporates govern the economy of the country, and India is a fast growing nation, fast growing economy. We intend to become 5 trillion economy. And this flip side of our economy will be managed by these institutions, NCLT and NCLAT, and these body of professionals. Therefore, this kind of education programs which experts like you are conducting will definitely a great help, a great thing to happen in this field. And I again congratulate for this, and I think this is a wonderful effort by you.
Dr. Kothari, the bonding both of us share with each other is that we both of us are chartered accountants. Please share as to how the CAs and their CA qualification has helped in your judicial career. Your CA qualification has helped you in your judicial career.
Very nice. This is a very nostalgic kind of question, Rajesh. And being a chartered accountant is always a matter of privilege for all of us who are chartered accountants. Maybe we are serving different fields. I know many friends in judiciary, bureaucracy, civil services, even ministers, and you get a kind of edge and distinction by being a chartered accountant. So I was one of the lucky few who shifted from CA profession to legal profession in 1984 after practicing as chartered accountant for about 2.5 years. And I think I definitely got an edge as a practicing lawyer in my law practice and making a mark there in my legal practice in Rajasthan. I was invited to be a member of the bench, and in 2005, after 20 years, I got a chance to serve the judiciary as a judge in 4 high courts, big high courts of the country. And I think I've done my job better because of being a chartered accountant, especially in the law fields like IBC, corporate matters, simple balance sheet cases where a normal judge may not possibly understand the implications of balance sheet. A CA judge can perhaps appreciate it more quickly and more readily.
According to you, the qualification of chartered accountancy has certainly played a role while discharging even the judicial function.
Very pivotal role, and I think the bar people, the advocates fraternity, also gets very good chance to argue even complex accounting matters and economic matters in the benches headed by a CA judge. And of course, other judges are also equally competent. I'm not saying that, but being a CA turned into lawyer and then judge definitely confers some kind of advantage.
I'll cite you an example when I was sitting in benches in NCLT Mumbai.
Yes.
One of the council used a term CCPS, that is cumulative convertible preference share.
Oh, yes.
And you see, a normal person who doesn't have that type of background,
Yes.
it will be difficult for him to comprehend what CC PS
PS
is, and what purpose is it going to serve when it is converted or cumulatively converted with interest and all those things. So, having a CA qualification certainly makes a difference wherever you are sitting and in whatever capacity.
Because as chartered accountants, we deal with so many balance sheets. We know what are debentures, what are CCPA, what are shares, equity shares. So that difference gives you an edge. That's what I say.
Dr. Kothari, as a guiding factor for the younger generation, please share as to what inspired you to be in judiciary after becoming a chartered accountant.
That credit goes to my guru, Mr. Marudar Midul, a very senior counsel of our town, Jodhpur, who used to come to our place. And we were a family of chartered accountants, so there were many chartered accountants in our family. My elder brother, Mr. B.M. Kothari, was very eminent CA. Yes, unfortunately, both of them are not in this world now. But both of them inspired me to join legal profession in High Court as advocate. It was a difficult decision because at that time I was not even married boy. And matrimonial market of a lawyer is lower than a chartered accountant. But anyways, God helped me in taking the right decision soon after my marriage, and I became a lawyer. And this is how inspiration is my two gurus, B.M. Kothari Sahib in the CA field and Mr. Marudar Midul in the legal field.
Dr. Kothari, you had a long stint as High Court judge. You are an eyewitness of pre-IBC era, that is the BIFR and AIFR era, SICA to be more specific, Sikh Industrial Companies Act, and post-IBC scenario. What is your reaction on this?
Oh, it's a great development of law, Rajesh. And even before SICA and BFR and all these, people used to file civil suits in the trial courts for recovery of their money from the companies also. So, and Indian legal system, the delays are well known for all these number of years. So, this right from civil suits to BFR days to SICA days for SIC companies and now IBCA consolidation of all those is a very, very stark development, is very good step. I must congratulate the parliamentarians for thinking of this law and then making a comprehensive law on the insolvency directed more towards the growth of the to revive the concept as a going concern so that the assets of a company who has defaulted in the repayment of law does not go in disuse and they do not remain unproductive assets for the economy from a national point of view. So I highly appreciate the IBC as a law, as a special law, and very comprehensive provisions have been made, as you know perhaps better than me, for the revival and going concern concept in the IBC law. So it's a great development of law which deserves kudos and congratulations.
Dr. Kothari, the way I look at it, the basic difference between pre-IBC era and the post-IBC scenario is that pre-IBC we used to have the concept of debtors in control.
Yes.
And IBC has totally shifted the focus now on creditors in control.
Absolutely. And that is what the committee of creditors is now the supreme.
Supreme. Yes.
And the corporate debtors on default virtually goes out of the scene.
Absolutely, absolutely.
Creditors committee takes over and IRPs take over, and then NCLT being the adjudicating authority decides the fate of all this. So it's a complete shift from debtor being in control, who used to delay the recovery process like anything, and now committee of creditors who can take a joint considered decision in their own wisdom, in a joint for the joint benefit of the creditors, secured creditors and unsecured creditors, and therefore it's a complete departure. It's a good departure because ultimately it is creditors' money which becomes the source of finance for the corporate structure, the company assets itself. That's what it is.
Dr. Kothari, I have been in finance field throughout my life.
Yes.
We used to finance industrial financing for Haryana State Industrial Development Corporation. And I remember those days when BIFR and AIFR used to be there. There used to be the sweet distribution. Sweets were distributed when the corporate debtor was admitted into the BIFR.
BIFR, yes.
When potentially secure, you became potentially security or security in BIFR, there used to be sweets distribution in the family. That from today
Though
onwards,
unfortunate, we are sick. Happy to be sick.
nobody can touch us now.
That is what it
It
was.
used to be said that projects get sick, no promoter gets sick.
That's right.
That was this era at that time.
That's right.
And today, the focus is entirely different on criteria. Criteria take over the company totally.
Company totally, yes,
And
yes.
the person is on the road. I have seen people were coming to us arguing as a managing director, and the order insolvency is admitted. The corporate debtor is admitted into insolvency. He goes. He is just,
Rajesh, I think the sweets were distributed because of the automatic stay provisions in CBIFR Act,
Exactly.
SICA Act, that the moment it is admitted, nobody can touch you.
Yes.
And therefore you are happy.
Yes.
And as you rightly said, debtors do not get sick. It is the company and the creditors who get sick. And you have to run after all this.
And those were days when somebody was admitted into, some corporate debtor was admitted into SICA, this BIFR.
BFR.
After 25 years, when when the company is admitted or declared sick, his child was born, and by the time his child is getting married, at that time there is some decision.
This is
of some sort.
Now this is an unfortunate tale for all judicial institutions. I think we should devise some way, at least for these special laws like IBC, where a fast track justice is done. And in that, my thought, Rajesh, is that we should have more adequate number of the judges in NCLT and NCLAT who can not only adjudicate the issues, complex issues and complicated facts and figures in a quicker manner, but the companies, the very purpose of this law, that the company's assets do not go in disuse, is protected. The main purpose is the assets should survive, they should remain productive. And for that, whatever mechanism has to be put in place for quicker decision and quicker adjudication, deciding various questions which arise in new law and have been arising right up to Supreme Court. Everybody is kept busy in interpreting the various provisions. So I think with this expeditious disposal of the cases, after a few years, we will see this law as a very settled, good law.
Dr. Kothari, as you must have observed, that IBC law is such a vibrant legislation that it has been amended 6 times within a span of 6 years.
I don't think amendment of law is a taboo or should not be done. Amendment of law I see as a development of law. Whatever contingencies require such amendments to be made in the law, they should be made, and why not?
So that clearly shows the proactiveness of the regulator for timely responding to the needs of the business. What is your experience with other legislations? Have you come across any other legislation which has been amended in such a faster pace?
Unfortunately, no. And it is very good thing that the parliament and the relevant committees and bureaucrats keep their tabs on the development of this law. And law has been amended time to time in a very good manner, fast manner. And the Honorable Supreme Court must be credited, Honorable NCLT and NCLAT also, for doing their job in a very good manner for interpreting this law to the benefit of all concerned. So I think this law is developing very fast. And as I said, after a few years down the line, I see this law as really thriving law, working law for the benefit.
As a matter of fact, another amendment is due in ensuing session of the parliament.
Okay. To benefit and suit their client's cause. It's not that they are doing something wrong, but there are always interesting questions of law which deserve to be interpreted and decided by the constitutional courts. And I think high courts and Supreme Court are doing very good job on this. We have series of judgments in IBC law after 2016 itself, which interpreted this law. And therefore, there is not an impediment. This is real process of development of law. I see like that, and therefore I don't see anything wrong in that.
As a matter of fact, what I have observed personally also,
Yes.
that Honorable Supreme Court is very proactively delivering the judgments in IBC cases. Very
Yes.
proactively and very fast.
That's what I also. Justice Rohinton, you see, for example,
Oh, yes.
wrote so many judgments
Yes.
and a series of judgments
Yes.
because he knew, perhaps, Honorable with his colleagues, that this law will be either a contributing factor or a stumbling block in the process of economic development, and therefore it is very necessary that the final court decides the various provisions and interpretations, giving it a finality in a nice manner.
Dr. Kothari, judicial pronouncements play an active role in development of any law. It is quite obvious as the interpretation of law is done by the courts.
Yes.
Even IBC is not an exception to that.
As you rightly put it, Rajesh, that interpretation is the job of the constitutional courts, and IBC certainly cannot be an exception. And this being a consolidation of so many complex laws and so many economic activities in diverse fields take place, different nature of industries, different nature of corporate structures, complex structure of corporate structures, they give rise to several questions: guarantors' role, promoters' roles, directors' roles, their independence, their contributory negligence, culpable negligence. All these are very important factors. So these have to be, seen on the field how they are to be held responsible or not responsible. Therefore, this interpretation business is very, very important. And I think proactive nature of the honorable constitutional courts, including NCLT and CLAT, has played a very, very pivotal role in this, and heads off to them for this.
Dr. Kothari, IBC 2016 clearly provides that if the existence of debt and occurrence of default is established and the default is above the threshold limit of rupees 1 crore, the adjudicating authority, that is NCLT, has not to look for anything else except admit the corporate debtor into insolvency. This is the law which has been reiterated by Honorable Supreme Court in plethora of cases. It's a series of judgments on this. But somehow Honorable Supreme Court has laid this law in umpteen number of cases. However, in Vidarbha judgment, Honorable Supreme Court took a different view. What is your considered opinion about that?
It's a ticklish question, Rajesh. And though the law provides for a cutoff limit and the obligation of the adjudicating authority to admit the petition and appoint IRP, but the words used in that provision are may.
Yes.
So may is generally, as you know, is not to be read as shall. So may gives a discretion to the NCLT, the adjudicating authority, to admit and appoint IRP and oust the management of the corporate debtor from the management. That requires that discretion in the embodied in the words may requires, I think, application of mind. It's not an automatic law, and its implementation is never works like a machine. Had it been so, perhaps with the development of artificial intelligence, the robots would have done the job. Then why do you need the judges? Therefore, in my humble opinion, Vidarbha judgment is the correct interpretation, though it's a later point of time and a departure from the earlier legal pronouncement, as you rightly put it. But then I think the NCLT ought to apply its mind, because you are taking a decision which has very severe and very great impact on the corporate or the company concerned itself. So I think application of mind, giving of reasons is a good thing to happen. So I would respectfully agree with Vidarbha judgment.
Straighten the records on this issue, Dr.
Yes.
Kothari. You see, what had happened is in Vidarbha judgment, Honorable Supreme Court took a view that NCLT, and while confirming the admission of the company into CRP and CLAT, has not have both of them have not uh, taken into account the specific circumstances of that case, facts of the case. In this case, some arbitral award was already in favor of the company.
Okay.
And since the company was having about, if I'm not wrong, it was 350 crore or something like that. If they were already having a decided arbitral award in their favor, for which money was yet to be disbursed,
Yet to come.
the corporate debtor was very much in a position to pay the creditor.
Had it received, it would
Had
have
it
paid.
received, yes, he would have paid. So that was the case. And when the review petition was filed in Vidarbha case, the Honorable Supreme Court did not allow that review petition. However, clarified that Vidarbha judgment was passed on certain circumstances of that particular case.
Okay.
it need not to be followed in all the cases to come.
Article 141 not to
Yes.
apply, but 142 to apply.
Yes,
That's what
yes,
perhaps the Honorable
yes.
Supreme Court has said.
But what has happened because of Vidarbha, you know, you can, who else
Okay.
can tell better than you that a superior court's judgment has to be followed by all the
Lower courts, including
in,
high courts and tribunals.
so, Honorable Supreme Court passed Vidarbha judgment, and after that, NCLT and NCLAT. I was reading somewhere, and it's in public domain. In more than 50 cases, the Vidarbha judgment has played its role.
Oh, it has stopped the case.
In insolvency proceedings.
That can be because I think, as you rightly explained, Rajesh, that the Honorable Supreme Court has clarified that let it not be a precedent for all.
Yes.
This was the particular facts.
But by the time this came, 50 cases were already were somewhere.
I quite see the point in your query and your submission also, that this kind of exercise of the discretion can perhaps delay the proceedings to a large extent. And what was the provision? The matter of then giving the provisions specifically.
And the NCLT benches are then accused of delays and all that.
You may be right there. But yes, let it not remain a precedent. But then, the facts of this nature which happened in Vidarbha can be elsewhere also.
Yes.
There can be arbitration award in favor of many corporate debtors,
Yes.
maybe in execution proceedings there. And as you know, execution proceedings itself takes a long time sometimes.
To be specific,
And you can't wait for
54 cases were affected because of this Vidarbha judgment at the level of NCLT or NCLAT.
Sometimes, these orders of 142 cause some kind of conflicts also. I can quite appreciate that also. Yes.
Dr. Kothari, as per waterfall mechanism provided under section 53 of the IBC 2016, the government dues are positioned at a lower ladder.
Yes.
However, rainbow judgment treated it differently. I'll tell you how it had happened. In rainbow judgment, the Honorable
Justice Indira Banerjee perhaps wrote that judgment.
Yes, the Honorable Supreme Court distinguished between a secured government creditor and an unsecured government creditor. And they said the secured government creditor is to be treated at par as secured financial creditor.
Yes.
Something of that sort.
The government dues will rank at par with them.
Upper on ladder. However, in Rainbow 2, Honorable Supreme Court has again brought back the original position, which is already written under section 53 of IBC.
Yes, you can complete your observation.
So, I just wanted to request you to share your views on that.
Raji, I would think that government dues, most of the provisions where the government dues are determined, provide for a first charge of the on the assets of the company whose SSC before them, and therefore government due should rank according to law also. But now lower in ladder or higher in ladder is a matter of statute. And you rightly said section 53 gives a waterfall mechanism, and that the words used are firstly, secondly, thirdly, fourthly. That is what waterfall mechanism is. And I believe that is the spirit of the parliament and this law, that it should fall like that only. Therefore, taking it up in the ladder by the judicial interpretation with great respects was not correct. And I think that is why Rainbow 2 has resulted in bringing it down as per the statutory provisions. That's a fair interpretation.
In fact, as in Rainbow itself, the security was already acted upon by the creditor,
by the
government
enforced.
It was already enforced.
Yes.
So when security has already been taken by them in charge, I think the Rainbow judgment in that way was rightly
particular facts. That once realized, you can go out with that.
The security interest was acted upon.
Yes.
And the asset was already taken
and
over.
And the excess realization should come in the kitty.
Dr. Kothari, you have passed more than 50,000 judgments in your judicial career. In your long outstanding career as High Court judge, our team has taken out a few judgments authored by you as a company judge. Please share with the audience as to what was in your mind while delivering the judgment. Actually, the very purpose of inviting you as well as other honorable justice and NCLT and NCLT members is that the what happens is the judgment comes in black and white with us. We read the judgment and try to understand that what was going on mind, but the judge's mind never come in public domain. So that way we have tried to bring a unique show where the honorable judge himself can
You
say
you are trying to dive into the mind of the judge.
exactly,
Very good.
which can be
Yeah.
beneficial for the NCLT and NCLAT sitting judges in delivering their judgments based on the experience of past.
Rajesh ji, Sachin Tendulkar once said that the cricketer should speak through his bat and his runs rather than speak his what he was playing in his mind and
Yes,
what he
yes,
was
yes.
thinking about the particular innings and all that. So, of course,
So
whatever I was lucky to decide about 50,000 cases, main cases, the interim orders apart, some of which were very long and
So, one
reportable.
such case which has been taken out by us for your discussion with you, this is Aerodrome versus Kingfisher Airlines, if you remember.
Oh, yes, I
Uh,
remember definitely.
yes.
These were both cases authored by me from Karnataka High Court as a single bench. And both are connected Kingfisher Airlines and United Breweries.
Yes.
United Breweries was the guarantor for the Kingfisher Airlines, and their debts were, of course, due. They could not pay. They were all, promoter was Vijay Mali, as you know, everybody knows. And these winding up petitions came before me in Karnataka High Court. My courtroom was always full of senior counsels arguing on both sides, and it was very interesting case, Rajeshi, and I really enjoyed. And this again, I would say that being a CA judge played a very important role in my deciding those cases, and perhaps the great lawyers, good lawyers, also could not take me for a ride or court for a ride. And they were asked certain difficult questions also about balance sheet, about ratios, about proposals of OTS and all that. And this happened in a very interesting way. About 10-15 days the hearing went on, and then I decided both the cases. I ordered winding up of the Kingfisher Alliance and the United Breweries also. I believe both these judgments have been upheld up to Honorable Supreme Court, and the companies are in winding up. What really was working in my mind is very plain and simple, that if the company is really in that kind of red as your insolvency red shows, and it cannot come out, it is simply impossible, at least with the existing promoters and management it cannot come out, then winding up is the only answer. And you have to choose between the two ways: either you go towards solvency and revival, or you go towards insolvency and distribution of the assets. So the balance sheets spoke larger volumes than the what their uh, alleged or make to believe OTS proposals always, which used to come, sir, we are ready to dispose of the assets and we are ready to pay 9,000 crores to the creditors, SBI and all these people, and you please give us opportunity and this and that. But they were not bona fides. These bona fides were tested by court from time to time for last over a year or so. Even in my court, I waited for 2-3 months for giving them time, but nothing concrete could come. And therefore, finally, you have to decide either ways. And that is what the job of the judge is, giving them sufficient natural justice compliances time also, and then finally coming to a conclusion. One thing I would like to share very interesting in this Vijay Malia's two companies case, their balance sheets, printed balance sheet, were placed before the court at that point of time. And the company, when it was making profits, the front cover of the balance sheet was a big banyan tree. And every time, I don't know why, but the balance sheet front was trees only. Gradually, that trees started shrinking. And the last tree or the last balance sheet, it was a dry kind of a stem. One of the paras in the judgment you will find like that the board of directors itself realizes that they have gone from a big banyan to a dry stem. So this was just a background. And but otherwise, I think many creditors were facing hard days with these companies, and then finally it had to be wound up.
But very apt observation that the tree
Nobody argued that point, but it was, that is what the chartered accountant judge can understand.
Yes. One more case which my team has taken out is the Pratibha Shipping versus Praxis Energy.
Yeah, yeah. Madras High Court, I
Madras
was
High Court.
there. and decided this question. Very interesting question again, Rajesh. And the question it was Admiralty jurisdiction, because being coastal High Court, yes. Madras being a chartered coastal High Court, enjoys the original jurisdiction of Admiralty law. Before 2017 Admiralty Act, this law was governed by a Supreme Court judgment in the case of Elizabeth Shipping. And that's a very interesting long case which I read at that point of time also. And the question in this case which I decided was whether the original civil suit filed in the Admiralty law could be tried by the learned single judge of Madras High Court without taking the leave of the court under section 446(2) of the Companies Act, where the Bombay High Court was seized of the binding petition and the against the same company, and they said without their leave you can't proceed with the suit here. That was the very interesting question. Then I decided after elaborate arguments that no leave is needed. Admiralty law is a special law. It will prevail, and winding up is a general law in that sense, though Companies Act is a special law again. And therefore, this leave of 446 from Bombay High Court is not required for the learned single judge to go ahead with the trial.
It can be tried here.
It can be tried here. So, very interesting question of Admiralty law versus corporate law. Before.
And one more case is Lalita Ben Govind Bhai Patel versus GSFC, Gujarat State Financial.
You see, that is the advantage I have seen. You have taken out my Karnataka judgment, Madras judgment, and in the end, where I retired as Gujarat judgment also. Thank you for making all that research. And this was again a very interesting question where the lawyers argue that you cannot transfer a pending vending a petition from High Court to NCLT. This was the question, because otherwise law requires pending cases to be transferred to NCLT. They said, no, sir, it has advanced a long way, and now the Honorable Learned Single Judge is seized of the binding petition. Therefore, you should not transfer. I was hearing a LPA, the intra-court latest patent appeal against the Honorable Learned Single Judge, who rejected the writ petition, and I, with my brother judge, was in division bench. So we decided finally by a long order in this that no, because NCLT is an expert body. The High Court may not have that kind of expertise, and therefore these are questions of facts, very complex accounting problems, all these complex transactions of loans and all this. Therefore, NCLT is better suited to decide this, though there is no transfer provision specifically to transfer old pending cases. But then Honorable Supreme Court in one of the cases had decided, I'm missing the name, that where it is not advanced stage of the winding up, then the High Court should transfer the case to the NCLT. And in that case, we ended up saying that it deserves to be transferred. Therefore, we recommend to the Honorable Company Judge strongly that he should transfer the case to NCLT. Finally, I believe that case has gone to the NCLT because the SLP against that was dismissed.
I remember this case. I was not remembering when the case citation was there, but when we explained, I was NCLT member at that time in Mumbai, and I complimented you for delivering this judgment at that time.
Thank you. So, you see, sometimes you, as a student of law, even on bench, you learn so many things.
Yes.
And the learned lawyers are able to give their versions in very different manner, with very supported by very, very well-reasoned arguments and case law also. And then it becomes a difficult job to decide such complex and intricate questions of law. And that is why all these 4 cases which you have very kindly cited were very, very interesting cases. They gave me a good learning, and I think the decisions rendered by me still hold the field, subject to, of course, Honorable Supreme Court.
So hope that way you vouch that we do some research.
Surely, and that is what the entire credit goes to you, Rajesh, that being such an honorable member of NCLT earlier and a very senior chartered accountant, you have thought this proper to invite guests like me, give us this opportunity to discuss various issues with you. And through this talk show, I think members of tribunals, legal fraternity, chartered accountants, IRPs, all will stand benefit. Ultimately, it's all for developmental law. We all work together. So thank you once again.
Thank you so much, Dr. Kothari. You have taken your time out and shared your views with us and the audience in this inaugural episode of the talk show, Insolvency Veterans. Thank you very much.
Thank you so much.
Thank you.